Hello, beautiful humans. Wonderful to see you. It is Friday, March 14th. It is a little after 5 o'clock Central Time, and I have a lot to share with you today. So the last time that I reported on Lori Vallow Daybell's Arizona trial was on Tuesday when she was in the courtroom for a status conference hearing. I just want to say, for those of you who are new to the channel, thank you for being here. Thank you so much for showing up to talk about Lori Vallow Daybell's trial updates. I am Megan Connor. I'm Lori Vallow Daybell's first cousin. We were close growing up. I spent a lot of time with the Cox family. I know most of the Cox family very, very well. And I've been commenting on Lori's trial because this is my family. I grew up with Lori. She was a bridesmaid at my wedding, and she and I spent a lot of time together. I lived with her and Adam in Austin for a short time, and her oldest son, Colby, and my oldest daughter were close for the first few years. They were growing up until they were about 12 or 13 years old. And the Coxes lived here in San Antonio for about 10 years, which means that my family, their family, we were together for gatherings several times a year, birthdays, holidays, all of those things. So that's just a little bit about who I am for those of you who are here for the first time, just in case you're like, who is this person that is reporting on Lori's trial? I just want to check my settings here real quick because I think I am on the wrong microphone. That might be because my microphone is not plugged in. Okay, now there we go. Okay, we're all set. All right, sorry. Thank you guys. Thanks for being here. I have a lot to go over today, and I'm just going to give you a quick agenda just so that you know what I'm going to talk about. And then you can, if you're watching this on the replay, welcome. Thank you for being here. You can skip through to the parts that are important to you. So here's what we're going to talk about. First of all, there was a motion that was filed by Lori on March 10th that was not mentioned in the Tuesday hearing, and it wasn't posted until a couple of days ago. And so I was taking a break at that time and didn't see it come in. So we're going to talk about this latest motion. And then we're going to go over just a little bit of the Tuesday conference, just a couple of minutes of it, because it's pertinent to that filing that we're going to talk about here in just a couple of minutes. Then Judge Boreski just earlier today released some decisions on the motions that were discussed in Tuesday's hearing. And then we're gonna go over Lori's witness list just a little bit because I want to highlight a couple of the names that are on there. And then I'm going to talk about my pending decision about attending the Arizona trial, how much of it I'm going to be there for. I haven't made a final decision yet, but maybe you guys can help push me over the hump of making that decision. So thank you for being here. I would also just like to ask you, if you're not subscribed already, about half the people that watch my videos are not subscribed. It's the best free way to support the channel. And I also want to plug my sponsor, Revolutionary Media. Revolutionary Media is a company that is dedicated to helping ordinary people like you and me turn their skills and expertise into monetizable content. If you're nervous about navigating the world of social media and especially YouTube, Revolutionary Media can help you take your idea from that first spark all the way to monetization in about 30 to 60 days. And they're going to help you avoid a lot of the pitfalls that I made when I first started as a creator. I wasted a lot of time and a lot of money making silly mistakes, and Revolutionary Media has been able to plug me into the resources that are the most efficient for what I'm trying to get done. So if you're interested in talking with Revolutionary Media about your idea, especially if you're over 40, because YouTube has become the go-to place for people over 40 to get new ideas and information on topics that they're looking for an expert on. So if you're over 40 and you have an area of expertise or just a hobby that you're really good at, Revolutionary Media can help you monetize that and change it into content that's going to benefit you in the future. My website is third-verse.com, and I have a little form you can fill out there where I can have Revolutionary Media contact you. I also do one-on-one coaching in person as well as virtual online, and there's also information about that on my website as well. So I'm going to go through and just start any questions as I see them come up, and I will try to make sure that I get to those towards the end of the the chat today, the live stream today. So first, we're going to go over the motion that was filed on March 10th by Lori Daybell. I'm having to look in multiple places because I don't have my windows organized the way I want them to. But hey, here we are, just an impromptu live, right? So the first thing I wanted to go over is this motion that Lori filed on the 10th. And this is a motion in limine to preclude the expert testimony of Daniel Coons. Now, Daniel Coons is a retired police officer who was on the scene in Chandler, Arizona on July 11th of 2019, the day that Charles Vallow was shot. Now, Charles Vallow is Lori's fourth husband, and this trial is for conspiracy to commit murder in Charles's death. And at the time that the shooting occurred, Alex Cox called 911, although 45 minutes late. And he told police that he had shot his brother-in-law in self-defense after an altercation. So this officer was there that day, and the state had this officer on their witness list previously, but did not designate him as an expert. And so now that he's been designated as an expert, Lori is filing this motion in limine to preclude his testimony. The facts are as follows. This is from the motion. The state filed a supplemental notice of disclosure to the defense 4 weeks before trial, noticing retired Daniel Coons, number 258, as a, quote, firearms expert. Previously retired Daniel Coons was listed as Detective Daniel Coons of Chandler Police Department, not as an expert. It is the understanding of the defense that Detective Coons was the scene agent on July 11, 2019, the day of the alleged crime. Now, 4 weeks before trial, the defense is being notified that Detective Coons will not be testifying as a scene agent, but rather as as a firearms expert to give his opinion, she has underlined. Detective Coons' opinion as a detective would not be admissible in trial, so the state is now naming him an expert so he can give the jury his opinion. She keeps underlining every single one. A CV attesting to the expert's qualifications has not been made available to the defense, nor has a defense interview occurred. For over a year, Detective Coons has been listed as a witness and not an expert. Noticing an expert allows the defense an opportunity to recruit a rebuttal expert. However, the absurdity of the timing of the disclosure of this detective now turned expert violates due process. This is not sufficient notice to even 1, locate an expert, 2, request funding approved by OPDS, 3, have our expert perform their own analysis, or 4, complete a report, and 5, prepare and testify at trial. The defense believes this is a tactic used by the state to prevent the defense from offering a rebuttal expert. Federal Rules of Evidence 702. I want to give a little foreshadowing. This is going to come back to bite her, I think. The use of the term expert in the rule does not, however, mean that a jury should actually be informed that a qualified expert witness or qualified witness is testifying as an expert. Indeed, there's much to be said for a practice that prohibits the use of the term expert by both parties and the court at trial. Such a practice ensures that trial court do not inadvertently put their stamp of authority on a witness's opinion. She underlined that emphasis was added by her, I'm guessing, and protects against the jury being overwhelmed by the so-called expert. Now, this is Lori. The defense concludes that this detective, who's been listed as a witness for over a year and is now being identified as an expert, has been inserted by the state for the purpose of giving his opinion under the false banner of expert at the last minute before trial. The defense requests that retired Detective Daniel Coons be precluded from offering any expert testimony at trial since it's a violation of the due process rights of the defendant. Now, I want to go back just a second because the rule that she quotes here from Arizona Rule 702, it's basically saying, this part of the rule is saying that you have to qualify an expert and can't just refer to someone as an expert without the qualification being offered. Now, that has really nothing to do with the argument that she's making here. And the reason why is because I'm going to go to the actual 702 code. And I'm going to talk about the part that does apply to what she's saying here. Give me 1 second to pull it up. Thank you for being patient with me, as it takes me a little while to get all of this done. Okay, so we're going to Rule 702. So sorry, this is taking me a minute because I just have so much text to scroll through. Okay. Under Arizona Rules of Evidence, Rule 702, an expert witness must have specialized knowledge, skill, experience, training, or education that helps the jury understand evidence or determine a fact in issue. Law enforcement officers can qualify as experts if they have sufficient experience in a relative field. Now, Detective Coons is retired. He was an officer for years. And so he probably does have specific training in firearms that would qualify him as an expert. And the state is going to present those qualifications at trial. Now, Lori can push back on it. She can voir dire him to see if he actually is an expert in these things as well. And then she can either object to the expert or not, and the judge can overrule her objection if he believes that the person qualifies as an expert. The thing that's interesting is that she objects to the timeline. Now, according to what Judge Boreski said at Lori's hearing on Tuesday, there have to be 30 days of notice before someone determines someone is an expert, and that way they can call a rebuttal witness and they can interview the expert, et cetera, et cetera. Well, the reason why this motion is interesting that she filed is because in her hearing on Tuesday, she herself announced that she will be calling an expert witness not previously disclosed to the defense. Now, the defense disclosed that this would be a witness, going back to what Lori alleges here. Too many documents, too many screens. I always have 63 tabs open. Okay. Supplemental disclosure was filed. It says 4 weeks before trial. It doesn't give a specific date. I just want to make sure that it doesn't give a specific date. But 4 weeks before trial starts on the 31st. And so I would assume that the state disclosed that this person is going to be an expert probably sometime around the 28th of February, maybe the 1st of March, right? Okay, so just put a pin in that. Okay, so the state disclosed this at least 2 weeks ago, right? Then on the 10th, on the 11th, at the status conference that was held just this past Tuesday, I'm going to go ahead and share my screen so we can see what happened there.
All right. Do you plan on calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today as an addendum to the
Who's that?
witness list that, Lonnie Dworkin.
All right. That's your investigator?
No, my investigator, Jeff White.
Oh.
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right. Expert reports and disclosures are due 30 days before trial generally under the rules. So if you're planning on using that witness, you need to get that disclosed right away, and I may have to take that up depending on what the state's position is. But
Your
at this
Honor,
point,
that
it's technically late.
may be another reason to be here on the 18th. Obviously, if that's disclosed this week, we can potentially address that issue on the 18th.
All right. Let me ask the defendant, do you have a position on the taking of prints
Okay, so that's really all I wanted to play from the conference, just because. So Lori filed a motion the day before this conference to complain that the state did not give enough time to designate this witness as an expert. And then literally one day later at the conference, she discloses that she has an expert that she has not previously disclosed to the state and for which the state has not had time to prepare. She's technically passed the 30-day rule on this. So she filed a motion to call out the state for the timing, and then she herself violated the timing. Is anyone surprised by this? No. This is something that manipulators do. They're going to call out somebody else for breaking the rules, and then they're going to break the rules themselves. So all I wanted to say about that is I don't know if the judge is going to grant her motion to preclude Detective Coons, because here's the thing. Detective Coons has been on the witness list for over a year. He was not specifically designated as an expert at that time. However, so technically both sides have a point here, right? Muted. Okay, so technically both sides have a point here, right? Lori is correct that if they waited to designate Detective Coons as an expert, she could have a point. She has the right to call a rebuttal witness for that. She has a right to depose Detective Coons about what he's going to say. However, then Lori herself makes a violation of the same 30-day rule. So basically, I think what's going to happen is that Lori's going to go ahead and scurry to get in her expert witness document that the judge referred to in this filing or in this status conference. And then the state is going to have a chance to do the rebuttal. So there is going to be another conference this coming Tuesday on the 18th. I will definitely be covering that because the judge is going to be going over that expert witness as well as some of the other motions that have been filed. So I think that's pretty much all for this motion that Lori filed. She basically is complaining because, yes, the witness has been on the list for a long time, but he wasn't designated as an expert. And here's the other thing I wanted to mention. She states the word opinion over and over and over, saying that they can't give their opinion. That's actually not true. Under Rule 702, if the officer has specialized knowledge, they can be deemed an expert, and also they can testify as to their observations on the scene. So I'm just trying to look at my notes here, just saying the judge will determine whether Coons' opinion, expert opinion or lay opinion, is admissible, focusing on his qualifications and the disclosure timing. Basically, he can give his opinion, his professional opinion, right? Lori's argument that he can't state his opinion is wrong because it's not just his opinion on like what he thinks about her curtains or the mirrors in her room. He's giving his opinion on what he observed at the scene as the officer on scene. So anyway, both sides have a point there, and we'll find out on Tuesday what the judge is going to rule about that. So I do appreciate you guys being here. I appreciate your support. Somebody asked for my Cash App, and I never remember what it is, so I'm gonna have to look it up, you guys. I'm so sorry. I should always have these things, just handy. My Venmo, though, is the same as all my social media. It's at _verse. If you want to send money there, I really appreciate your support. It's very kind of you. I think it's awesome that people want to support me. And sometimes this platform, they take their cut. So here's my Cash App. It's the $sign and then third verse MC. My regular thing wasn't available, and that's why I always forget it. But thank you so much for your kindness and your support. I always appreciate it. And I agree with you, Justine. Sadly, the entire trial is going to be full of nonsense like this. She can't help herself. I will give her a little bit of credit for trying to make some arguments that do seem based in some sort of fact and do seem based in some coherent arguments. I think that the advisory council is doing a good job of listening to what she wants to argue and helping her along with that. However, I don't think that it endears her to the court to use explosive language or to underline things, to use exclamation points. You know, I just think that the way that she goes about it it's the Lori way, right? She's grandiose. She's going to try and call attention to things in sort of a weird way. So that's all I have to say about her motion. Again, we'll hear on Tuesday what the judge is going to rule about her expert coming in. And I'm sure the state will have some pushback on that. And as well as the state's expert and this with Lori's motion. So here's the next thing. The judge wrote a decision about consolidating the trials. Okay. So this was on March 11th, immediately after the conference that happened on Tuesday. He notes that the matter concluded at 9:27 a.m. and this is his order regarding some of the things that were discussed. Now he's got two orders we're going to go over. This is the first one. It is ordered denying the defendant's request to consolidate trials. So we're not going to be consolidating trials. If you remember on Tuesday, the judge wanted Lori to know, like, sometimes there is some prejudicial rub off. If you consolidate both of those trials, the jury's going to hear evidence for both trials, and that could sway their opinion. So it's generally not recommended to a defendant that they consolidate two separate trials for two separate charges. So that's what he's going to say. It says the court's minute entry ruling regarding media access, which was filed September 4th, 2024, provides the appropriate findings regarding why the court is overruling the defendant's continuing objection to media coverage. So in the Tuesday conference, he overruled the objection to media coverage. The reasoning and findings contained therein have not changed. However, the court finds no compelling public interest in broadcasting the jury selection process that outweighs the juror's statutory right to confidentiality. While transparency in the legal process is important, juror anonymity strikes the necessary balance between openness and the burden placed on those responsible for delivering justice. In addition, anonymity ensures that potential jurors, will give candid answers to questions asked during the voir dire process. Broadcasting jurors' answers during the jury selection process could chill the willingness of jurors to give complete and candid answers. I agree. Thus, broadcasting increases the likelihood of harm to the party's right to a fair and impartial jury, insulated from potential extreme influence, and a verdict based solely on the facts of this case. For these reasons, pursuant to cites the rules of criminal procedure, it is ordered that cameras will not be allowed in the courtroom during the jury selection process. It is further ordered granting and denying the media requests in part. It is further ordered denying the request for more than one outside camera being present in the courtroom and denying the request for the use of a still camera in the courtroom. So there will be no still camera. There will just be one video camera in the courtroom. It is further ordered that the jury is selected and sworn, that once the jury is selected and sworn, media coverage will be limited to one pool camera positioned in the back of the courtroom. The pool camera, one, shall not broadcast, stream, or otherwise distribute any courtroom footage not less than 30 minutes after. So there's a minimum of a 30-minute broadcast delay for that one pool camera. Number two, shall mute any audio during bench conferences. In other words, the conversations during any bench conferences between the court and the parties shall not be broadcast. And number three, shall not capture, record, or broadcast the image or any portion of any juror. Turning the page here. Number four, shall not film any witnesses or attorneys who approach or leave the witness stand area, as that may inadvertently capture jurors in the background. Number five, shall screen and edit out any inadvertent filming of any juror prior to broadcast. And number six, shall not zoom in or focus on and record/broadcast any materials on the attorney's desks and or materials being held or handled by the attorneys or defendant in order to prevent the unintentional broadcasting of any privileged or work product materials. So you heard that addressed in the conference, the status conference on Tuesday, where, Lori wanted to make sure they weren't going to zoom in on the materials on her desk. So there will be one pool camera. There will be a 30-minute delay, and nothing is allowed to be broadcast that has any juror faces in it. It is further ordered that any witness or next of kin who object to their face being shown shall inform the court prior to any testimony. The Arizona Constitution requires the Arizona Commission on Judicial Performance Review to conduct performance evaluations of Superior Court judges. The commission is asking for your help to evaluate Maricopa County Superior Court judges currently undergoing performance review. After your hearing, if the judge you are in front of is undergoing review, a survey will either be given to you by court staff or will be emailed to you, and you can take the survey online. The survey is conducted by the Docking Institute of Public Affairs at Fort Hays State University and is anonymous and confidential. Your participation in the review process is important. More information on judicial performance review can be found at azjudges.com.info. Just wanted to include that because it's in the document. It's not really relevant to what we're talking about right now, but I just thought I would include it. I don't think that it's at the bottom of every motion. But here is a continuance of the judge's decision. I guess I should probably have read this one first, but that's okay. Julie Wilburn, thanks so much for this super sticker. This judge seems very fair, and I look forward to seeing how he handles this trial. I think Lori may be wishing she could portal her way out of things. Definitely. I agree. The judge seems very fair. He seems to be helping Lori with some things, but he is also holding her feet to the fire. Can you explain this to me? Can you explain why you're making this argument? He's not allowing her to just get away with anything, but I think he's being fair to allow her, to argue these motions in court. And I think that his decisions so far, from what I've seen, are very fair to both the defense and the state. And that's good. We want that. We want the judge to be fair and impartial. That's his job, right? So this, again, is right after the status conference decision written on March 11th, 2025. Let the record reflect that Matthew Kelly presents an argument to the court on behalf of Court TV. The defense objects to the requests and the state takes no position. After discussion, the court will issue detailed orders, which will appear later in this minute, which I've already read. Discussion is held with respect to jury selection. The court will hold jury selection in courtroom 5C in the South Court Tower, but trial will be held in this courtroom. And that's one of the things people are commenting on. This is a very small courtroom. There are only 36 seats. So it's going to be hard for people to get in. And I will talk a little bit more about that in just a second. It's ordered that the state shall file a joint pretrial statement, including a witness list by Thursday, March 13th, so that the court can include the names in the questionnaire. So that obviously was yesterday, and we haven't seen it yet. It just takes a while for these things to come out. Discussion is held with respect to defendant's motion for specific discovery, communication between assigned deputy county attorney and law enforcement agencies, and the videos, reviews, and the state's responses. After discussion, the court finds that based on the avowal of counsel for the state that all discovery related to the communication between the assigned deputy county attorney and law enforcement agencies has been disclosed, and the court makes no orders regarding the same. In other words, Lori was asking for an additional video of the time that she was in the police department being interviewed by police with Melanie Gibb and with Tylee. The state said, we've given her everything, and the judge is now ruling that is the case. She's received everything. He's not going to make an additional order about that. The state is directed to follow up with the Gilbert Police Department regarding the existence of interview room questioning, not body cam footage, which the defendant was told appears online, but the defendant states was not disclosed. I've never seen anything like that. I don't know if you guys have, but I've seen the body cam footage of that interview. I have not seen any overhead video of that. Somebody told Lori that existed online somewhere. I have not seen it. And I did note that during one of the previous trials, I can't remember which one, that sometimes the recording equipment doesn't work in the interview room. And that's why they have the body cam footage available. So there's that. Just going back. Discussion is held with respect to the state's motion in limine regarding Alex Cox's statements. Okay, this is an important one. After discussion, it is ordered granting the state's motion. If the defendant believes the state has opened the door to the introduction of any statement by Alex Cox, she will first need to alert the court outside the presence of the jury prior to the attempted introduction of any statement of Alex Cox being introduced. So this is where Lori's going to have to think on her feet. If the state opens the door to any statement by Alex Cox, then Lori will have to ask to approach the bench. She'll have to go up and say, I object to this statement being introduced, et cetera, et cetera. Then they'll have a discussion. It says discussion is held with respect to the state's motion in limine regarding Tylee Ryan hearsay statements. After discussion, it is ordered granting the state's motion. So that both of the state's motions to have Tylee and Alex's statements to police after the shooting have been granted. This is huge because both Alex and Tylee's statements to police support the idea that the shooting was done in self-defense. If those narratives are not allowed to be introduced into evidence, then Lori really can't argue that this was a self-defense occurrence, or she's going to have a really hard time proving that if those two statements are not allowed to be admitted. Probably they'll address the 911 call maybe here in a second. If it doesn't, I'll go back over it. After discussion, it's ordered granting the state's motion. The court finds all statements of Tylee Ryan to be hearsay, and the defendant has not established that any specific statement is either non-hearsay or falls within an exception to hearsay. If, however, during the course of the trial, the defendant believes a good faith basis exists under the law to introduce statements of Tylee Ryan, she shall first notify the court outside the presence of the jury. So there again, she's going to have to object to anything that's being brought into evidence with regard to that. Discussion is held with respect to the state's notice of disclosure and request for disclosure. The court informs the defendant that any expert witness needs to be disclosed as soon as possible and is at this time technically untimely, Lori. Discussion is held with respect to defendant's courtroom movements and presentation during trial. It is ordered affirming the trial date of March 31st, 2025 at 10:30 a.m. before Judge Boreski. That's good to know. It's further ordered resetting the final trial management conference on March 18th, 2025 at 8:30 a.m. to March 18th, 2025 at 8:15 a.m. They pushed it up 15 minutes before Judge Boreski to discuss the follow-up of the Gilbert Police Department interview videos, the status of disclosure of the defendant's expert, and the taking of fingerprints and other identifying information of the defendant. The camera shall not be present for the taking of the defendant's fingerprints. It is ordered that no time be excluded. The last day remains May 11th, 2025. That's for this trial. Discussion is held with respect to setting a firm trial date in the Brandon Boudreaux case. The defendant objects to waiving time. The court will waive time over the defendant's objection and will set a firm trial date as soon as possible based on the current scheduling in the Charles Vallow case and any conflicts of the parties or the court. It is further ordered affirming prior custody orders. So that is all for the judge's decisions on everything that was discussed on the Tuesday status conference that we just watched. I'm going to go back through. I did star a couple of questions, and I do want to discuss Lori's witness list for just a second, and then discuss my personal attendance at the trial. Again, I haven't made a final decision, but I'm a little farther along in that process today. So I'm always interested in what your opinions are and what is going to be most beneficial for you, the content that you're looking for. Thanks, I appreciate this. We appreciate you so much and any growing pains you've had. Yeah, it's been a wild journey. Again, never expected to be where I am right now, never expected to start a podcast, never expected to really have a YouTube channel, even when I started my podcast. So it's a wild place to be. This journey started with me publishing my book and wanting to speak publicly about my experiences surviving trafficking as a child. And so I never thought that I would be here doing this, what I'm doing now. And along that journey to get to where I am, I wasted a lot of time and a lot of money doing the wrong things, putting my efforts in the wrong places. And when I got introduced to revolutionary media, I was like, oh my gosh, this could have been so much of an easier process. And my very, very expensive hobby previously could have been a living for me a lot sooner. And I would have been able to quit my job instead of being fired. But that's a rabbit hole for another day. So I'm going to address a couple of questions that I just saw come up in the chat. Stacy Daubenberger says, if they stay in the smaller courtroom, is there a concern you travel there and not get a seat? Yeah, there's a slight concern. I do need to contact the court, which I plan to do on Monday, to see if I can possibly be reserved as a family member. So I don't know exactly what the qualifications are for that or what I have to do to get it done. Carolyn says, well, Megan, you have a YouTube channel in the same way Lauren of Hidden True Crime does. Why shouldn't you be allowed in? Well, there again, Lauren and I would be considered for those purposes to be media, even though she probably has credentials and I don't. So media would be first come, first serve, just like anybody else. So it would involve me showing up early, standing in line possibly to get in. And I don't know what that's going to look like until I actually get there. So that's a consideration as well. So Diane says, so can't the state subpoena an individual without telling the defense? Technically, no, they have to give you the witness list. The defense has to be able to interview those witnesses, to depose those witnesses and to see what testimony they're going to be given. And the state also has to disclose all of the evidence that they're going to use to try and convict Lori. She has to be able to review that evidence and to talk to all of the witnesses. And then Diane also asks, will she be able to go up to the judge's desk for sidebars? Interesting question, because on the Tuesday hearing, they discussed the fact that she's not going to be shackled, we don't think, but she is going to be wearing a shock vest. She will only be allowed to stay seated at her desk and to stand at the podium for her opening and closing statements and to address witnesses. They didn't say anything about going up to the judge's desk for sidebars. So I think probably what will have to happen is that her advisory council will have to go up for those sidebars and that Lori won't be allowed to be there, because I think that's part of the reason of having the shock vest is that the defendant can't approach the judge. So it'll just be interesting to see how that plays out. I do have a lot going on. Thank you for this. I am going to take care of myself. Definitely. It's possible for me to live stream on my channel. I haven't decided yet whether I'm going to do that, because logistically that presents a lot of challenges. I would have to, since I may potentially be there, I would have to have someone set up the live stream and then moderate the chat during the live stream. So I don't know how to do that yet. Just still figuring it out. Prior to this, I basically said I was going to let people go to Hidden True Crime. They've got that figured out. It's one less headache that I have to worry about. This is a good question. Spinster says, Megan, do you think you will smile at Lori if you make eye contact? It would feel instinctual for me to not smile out of habit. Curious if you thought of it. I don't think that I would smile at any Cox, maybe Adam, because we're on friendly terms. If I made eye contact with them, I have kind of thought about that. Like, what would I say if they did approach me? I don't plan to approach them at all, but I do have some things that I would say, but the public venue is probably not the place for that. So I wouldn't attempt to engage in a conversation, I don't think, especially not in the courtroom. I really just want to stay focused on listening to the testimony and looking at the evidence and seeing everything presented, and not have to worry about the relational dynamic between me and my family members. So that's going to be interesting to navigate. I definitely, MB, what my plan would be is if I do attend, would be to do a lunch live, probably just for channel members at that point. I haven't decided about that. and then to do a daily recap for everyone. So that's what I would do if I do decide to attend in person. If I don't attend in person, then I will live stream the coverage, and I will do commentary during breaks and a recap afterwards. So even though Lauren is media technically, I don't think she has media credentials, but even people with media credentials have to just wait in the regular line, just like everybody else. The pool camera, the people who are operating the pool camera, they're considered media, but they're the only ones. There's only one pool camera allowed in there. Now, I think probably that Justin Lum can be considered media, but I don't know if they reserve a seat for him or if he has to wait in line just like everyone else. As far as I know, this is correct, Northwest, that there's no reserved media seats. Thank you, Laura W. I appreciate this. I've had lots of people reach out to help, and I do appreciate that. Again, still figuring out my schedule. F my dentures, love your username, and thank you for this. I really appreciate this. That's very kind of you. Kaylee says, do you think Lori will be able to keep her anger under control? It seemed to be bubbling up even in that short hearing. Yeah, she does get very testy with certain things. And I noticed she was very flippant toward the judge, saying, well, the state can just figure that out. If they decide they're not going to, they decided that they probably weren't going to combine trials. And then Lori said, I just want to point out that the last day for the Brandon Boudreaux case, I think is May 12th or May 11th. And what they were discussing was starting that case, as quickly as possible after this case is over. And one of the things that Lori just pointed out was like, hey, guess what? The last day is coming up. And, if you postpone it, then the state just needs to figure that out. But I also notice what happens a lot of the time is that she'll get angry and agitated about something, and then she'll retreat back down to little girl voice and little baby voice. And I think she does that as a tactic to seem less, what's the correct word that I'm thinking? Less aggressive when she's, talking about the things that upset her. So she knows how to keep her anger under control. We saw it come out in the Dateline interview, but I think that was a little more of a casual environment. She's been very careful in talking to the judge in this case to keep things under wraps and to not get too out of hand. So she knows how to do it. It'll be interesting to see how long she'll be able to do it under pressure for an extended period of time in a courtroom with a jury present. It's going to be very interesting. They may have to have juries step out for sidebars since she can't approach. That happened several times in Chad's case as well. Talk about different things that the jury doesn't need to hear. So hopefully there won't be very many of those, because I don't know if you guys remember, but John Pryor had so many objections and sidebars that really prolonged the case. And I can imagine that Lori probably is going to try and do as much of that as she possibly can. Elizabeth says, I liked when the judge shut her down, questioned down about handling evidence to called witnesses. He told her no, it would not be allowed by her. So interesting. Thanks, guys. I just start coughing a lot. I appreciate you being here. Thank you for helping me recap this with you guys. I do want to look at Lori's witness list here in just a second. I don't know if there's going to be an overflow type room. Nate Eaton did encourage the public not to attend. I don't know how I feel about that, to be honest with you. He basically said, please don't show up so that I can get in, and that I'll just recap it and you can watch it on my channel. I don't know how I feel about that. She really does think that she and Chad are going to be exonerated. Absolutely. Yes, this is a great suggestion, Northwest. I do prepare sentences to have available in advance when I know that there's going to be a problematic person in the mix. I try to take my time, and I try to listen more than I talk. And I try not to say anything unless I absolutely have to. So this is good advice. Thank you very much. Appreciate it. Yes, please do remember to like. Thank you for all of you calling for likes and subscribing. I appreciate that so much. Her family, as far as I know, was not in the courtroom on Tuesday. Usually Justin and or Nate will comment on that if that's the case. Again, Janice does not live in Arizona, so she would have had to travel in order to be there. But Summer is there in Phoenix, in the Phoenix area. Northwest asks thoughts. I'm worried Lori will say Tylee shot Charles. Yeah, I think she is going to try and blame everything on Tylee, but I don't think the evidence bears out that narrative. And so, sorry, guys. I don't think the evidence bears out that narrative. And so I don't think it'll be possible for her to reasonably make that argument. I have a puppy visiting me. You can say hello. Yes, you can, but you're not allowed to sit on my lap because you're not a lap dog. You're too big to be a lap dog. This is Valkyrie, everybody. She's constantly sitting by me when I'm here at this desk. And sometimes she thinks that it's a great idea to jump up and get my microphone out of the way. Okay, so let's go over one last thing. I want to go over Lori's witness list because I got some clarification on that. I know, I'm sorry. Can you please go? Thank you. Go lie down. Go lie down. Okay. And I don't know how many of you have two fur babies or two dogs, but when one of them gets excited about going OUT, then the other one wants to go too. And so that's, sorry for the noise. Okay, so scrolling back down here to find Lori's witness list. I apologize that it's taking me a second to pull it up here. Okay, so the defense notices the following. Yes, they can spell. They are very smart. Okay, let's see. Number 2, the defense notices the following witnesses, and this is a long list, you guys. Oh, it's good to hear that Nate said that tongue in cheek. This picture does not show the letter A, so I don't know what is under the letter A, but letter B starts with any and all individuals including but not limited to victim assistance caseworkers and or volunteers who have spoken with any witness in this case. That's a lot of people that she's asking. So that's kind of problematic. And then C, all witnesses listed in the state's Rule 15.1 disclosure, as well as in any supplemental witness disclosure filing. So she's basically saying everybody that the state calls, I reserve the right to call that person as well. Sorry for anybody whose fur babies are activated by hearing my fur babies. Yes, my dogs are Valkyrie and Loki, and I feel like I got what I deserved by naming him Loki, the dog of mischief. Okay, and then D, the custodian of records for any and all exhibits. And then, which I don't think is customary. I don't think usually the custodian for exhibits is called as a witness in the case. So that will be interesting to hear what she has to say about that. Then Nate Eaton. Nate Eaton is called as a witness in the case. He hasn't received a subpoena. I watched his little video about that. Basically, and also, yes, this is true, Northwest, right? You can't call victim assistance people normally because that's not in their job scope, and they're not supposed to be called as witnesses normally. I don't know. That seems weird to me. Margeezy, thank you. This will go into the doggy treat fund. Going back to the witness list, Vaisia Itaahu. That is one of Tylee's really close friends. And I don't know exactly where she lives at this point, but calling Vaisia as a witness and having her being questioned by Lori, I think is just it's a horrible thing. It's a sad thing. I feel really terrible about that circumstance. And then Gabriel Bonilla, who I believe is Lori's bishop or was Lori's bishop in the LDS Church at the time that this happened. Now, this is a really interesting thing because, okay, thank you for saying this, Northwest, you must be an attorney or at least attorney adjacent. You need custodian of records to authenticate documents if not stipulated to by both sides. So if Lori has no objection about the evidence that's being offered, then fine. But if Lori objects to any of the evidence, then I guess she would call the custodian of records to authenticate the document. That makes sense to me. Thank you for clarifying that. So Gabriel Bonilla, if this in fact is Lori's bishop or was Lori's bishop at the time that this incident occurred, this is exactly what I'm wondering if the church will stop her from calling the bishop. The Church of Jesus Christ of Latter-day Saints has a history of protecting its clergy, even though they're lay clergy. These are not ordained ministers. These are people who serve in a volunteer capacity to be the leader of a congregation. And typically, they do not want their church leaders, their lay leaders especially, participating in legal proceedings. Hey, Kresha, Difficult Research. Good to see you. Thank you. Thank you for being here. Lori Zulema and Melanie Gibbs Bishop showed up with Charles when he had to break into the house. Jason Mao's business partner and illustrator. Wow, that is quite a connection. So I will just say the one statement that the church issued in regards to this case had nothing to do with mentioning the case or anything like that, except to say to the people in Idaho that they should talk with the church's attorneys before they give any witness testimony or any statements to police regarding this case. That is extremely telling to me. That tells me where the church's priorities are on this case. They didn't want to help find the missing children. They didn't want to comment on the case itself. The only reason we know that Chad Daybell was excommunicated from the LDS Church is because someone leaked that document. We don't know if Lori has been excommunicated at this point because nobody has leaked the document. And I was going to make another point about that. Oh, yeah, Tim Ballard of OUR fame. If you don't know who Tim Ballard is, the disgraced director of Operation Underground Railroad, a company that said, nonprofit organization that said that they were helping to rescue trafficked children, but then did not actually, in fact, rescue children. And Tim Ballard basically used those operations to allegedly engage in assaulting women. He was very publicly excommunicated from the church. The PR rep for the church released a statement saying that he was excommunicated. As far as I know, that's the only time in church history that that's ever been done. So they were perfectly willing to do that. And I would argue ostensibly because Tim Ballard was using the name of one of the apostles of the church, M. Russell Ballard, who they happen to share a last name. I don't think they're related, but they could be related. But the cardinal sin is making the church leaders look bad. And so that's why I think personally, in my opinion, that Tim Ballard's excommunication was so publicly offered, but nobody offered that for Lori and Chad when they are now convicted unalivers, red rummers. So I find it to be very telling of where the church's priorities are in regard to this case. So I will be really, really interested to see whether or not this bishop is going to be allowed by the church to testify in this case. The church's attorneys, I'm sure, are going to have something to say about that. They will probably file a motion to quash his appearance, which hopefully the judge will deny because, yes, he could claim religious confession privilege. However, if the evidence he has to give was not given under confession, then he can't claim that privilege. However, the LDS Church in the past has tried to argue in court that anything said to a bishop at any time could be considered clergy privileged confession, which I don't think there's a legal basis for that. I'm not an attorney, but I don't know. But basically, this bishop potentially has information regarding what Charles said to him about Lori and her crazy religious beliefs. He's got a lot of information if he was the bishop of all of those people. And if they were just talking outside of the confines of a, confessional situation, here's the thing. Like, I've talked to my bishop so many times over the years when I was a member about so many different things, like just passing in the hallway, that obviously are not considered confessionals. I've even asked my bishop for advice about things, not sitting in his office in an official capacity. So hopefully the legal arguments will win out here, and the bishop will be allowed to testify, because I think he has some important information. I don't think it's going to come from the questions Lori asks. I think it's going to come on cross-examination. So, I definitely want to get to some of these comments that you're making, Kresha, because I think it's important. You've done a lot more research on some of these things than I have. I can just comment on the Mormon angle and the Cox family angle. Gabe Bonilla has more to do with being hands-on, not necessarily on the church's behalf. What are your thoughts? Well, here's the thing. I don't think Lori's calling him to testify on behalf of the church. I think Lori's calling him to testify about some of the things that Charles said, and potentially some of the things that Tylee said. Now, again, that's going to be hearsay. But if he was with Charles when they had to break into the house, when the kids' things were missing, he can testify to that experience. He can testify to his personal experience with Lori. If I were the prosecution, I would want to ask the bishop about her temple recommend status. I would want to ask the bishop about, her level of activity in the congregation, about her, religious beliefs being outside of the LDS scope. So I guarantee you the LDS Church does not want this bishop to testify. I guarantee you they don't. Even if he's only testifying about his experiences with Charles, or his experiences with the parties in the case. I agree with you, Kaylee. I think it opens up a whole can of worms, and I don't think the LDS Church is going to be happy about it at all. Salty Sleuth, send me an email, maybe. askmegan@gmail.com. That's Megan with 2 E's, Meegan. If you're talking about Gabe Bonilla, I just would be interested to know how long he was bishop, how long he knew Lori. Nothing weird, anything you're willing, comfortable to share. Just out of my own personal interest. And yeah, I was listening to this Jason Mao interview before I went live as well, so I have some more to listen to there. And Kresha, money launderer, child trafficker, we're talking about Tim Ballard over here, creep as well. Kara J, thanks for becoming a new member. Appreciate that. Thank you. Kresha says the same apostle who urged him to start OUR then went in on slave stealers, Liberty 89, and invested along with 2 other apostles in Tim's OUR. For those of you who don't know, slave stealers and Liberty 89 were other entities where they had other surreptitious designs to try to sort of homogenize Mormonism, to make it more palatable, to sort of sneak Tim Ballard in as a Christian nationalist, and to get him elected to be president, and also to be the next prophet of the church. So lots of rabbit hole stuff you could go down there. Very interesting stuff, but again, it's a diversion. It's a rabbit hole for another time. I could go days and days and days down that rabbit hole. So I have deliberately chosen not to. I'm letting Kresha handle it. There's another YouTuber named Kara Burrell who goes by Nuance Ho. She has a podcast called Timmy Did What, where she talks with a former business partner and colleague and associate of Tim Ballard, and they break down the entire legal case with Tim Ballard. So if you want that rabbit hole, go for it. They do such a great job covering it. I don't know about this, Marjorie. Was Bonilla interviewed by police regarding things Lori Vallow said to Charles that he was witness to? I don't know. Okay, in my opinion, Kresha says Gabe Bonilla talked to a police officer and minimized destroy. He also called Gib and alerted her of the police presence at Zulema's house when he died December 2019. When Alex died, maybe? So yeah, there's probably a lot that he knows about that he could comment on. Yeah, definitely not a competition, just that, we have overlap, and I'm grateful for the research you've done because there's a lot of gaps in my knowledge, because I did completely check out of all of this between the time that the kids were found and the time that Lori went on trial. So there was a lot of information that came out during that time, and I am definitely playing catch up. Thank you, Krista Gardner, for saying that. If you have info you can point me to, I would love to see it. If you want to email me, askmegan with 2 E's @gmail.com. I would appreciate that, because I always just want to know. I want to have as much info as I can. Yeah, so this statement, Holly, that I referred to is the one that was early in 2020. And that was the statement where they didn't really mention what exactly was going on. They didn't mention names. They didn't mention details or events. They just said, hey, we don't want any of our clergy or members talking to the police or court officials or anything without talking to our attorneys first. So that is that. Yes, this is true. She's going to do the victim complex thing. I believe Melanie Gibb is on the state's list, although I haven't seen the state's list. But I'm going to assume that Melanie's on there, as well as Kay. So I never did finish going down the list. I just want to make sure that I do that real quick here. So we were talking about Gabriel Bonilla, who we believe is the bishop in question. Joseph Pongratz, I think, is one of the child victim advocates. I don't know who Ashlyn Rind is. Yes, and this is another thing to talk about. I just want to always mention, thank you, Kresha, for mentioning that Chad's publishing company sponsored a race in Rexburg the same weekend that Tylee was unalived. Chad and Lori were not present, but Tammy volunteered for the race. I think she did the race, but Emma Daybell was instrumental in organizing that. It was a fundraiser for OUR that weekend. I don't believe in coincidences, you guys. I just don't. I've had too much happen in my life. Yes, Lori's trying to bring in Gabe Bonilla as a witness. He's on the list. Okay, there's a recording of Gabe and police. Thank you, Ellen. If you want to send that to me at askmegan@gmail, I would appreciate it. I would love to go over that. And I agree with you, Kelly. I don't get it either. But I was indoctrinated into it as a young child. I'm a 7th generation Mormon. All of my family lived in Utah and were practicing faithful Mormons. The first person in our family to leave the church was my oldest cousin. She left when she was 18 years old. So that would have been probably sometime around 1990, I'm guessing. She was the first one in 7 generations to leave the church. That's a lot, y'all. I mean, when your whole family is doing it and it's hundreds and hundreds of people, it's pretty hard to break out. So I don't get it either, but I have a lot of grace for people who are in it, because you don't know what you don't know until you know it. Yes, and we know Tim Ballard uses fortune tellers. Deeper breaking news, he was using one of the prophets' fortune tellers, not the word they use. Yeah, it was basically a psychic or a medium, right? Yeah, Timmy Did What is a pretty good podcast. They do a great job. Nana of 7, good to see you again. It's been a while. Thank you for this super sticker. Go with your instincts as to go or not, or to plan and jump ship if need to. Would be happy to watch on Court TV, and you jumped on during breaks to give your commentary. Thanks. I appreciate that so much. Okay, cool. Crusher says, I ran across more in the FOIA reports today that I recorded and will share once I finish editing the video about Gabe Bonilla. Nothing much, but I included. Thanks. I would love to see that and go through that. This is true, Joe Tall Chief. Lori does seem to be absent when people are unalived. Okay, you're right. Thank you again, Kresha. Joe Pongratz was Lori and Charles's landlord. Joe was scheduled to meet with Charles on July 11, 2019, to show him other places to rent. And then, of course, Charles never did make it. I don't know why she's calling for Nate. I don't know. Because I think most of what he would have to say would be hearsay. I don't know. Sally Sleuth, thanks for this. I love going on Mormon stories. I love the band that we have. It's a great group of people, zero ego, lots of really intelligent discussion, and it's been helpful to me. Yeah, I'm sure the LDS attorneys have already started the procedures to block all of this. I'm sure that they have. We don't know this. We haven't seen it, but they probably would put in a motion to quash that. I got subpoenaed to testify in a case. I had to call an attorney to try and quash the subpoena, and it didn't work. And I had to show up anyway. I never did have to testify, but the judge denied my attempt to quash. So my attorney, I just had to pay for all that for no reason. And it was kind of annoying, to be honest with you. So just trying to make sure that I get, I wanted to know who, okay, so Kresha says Ashlyn Rinn testified in both trials already and was Tylee's best friend. Okay, Visa was Tylee's other. Okay, so those are her two best friends. Thank you for clarifying, because I didn't know all those names. And now just to skip down to the rest of the, I really wish that I could address all of your comments, you guys. So many good things that you guys are saying, and I appreciate it. Thank you for this, Kaylee. Thank you for that super sticker. Yeah, LDS Church does not want that to happen. Dom's mom says, I don't see how the judge would allow Nate Eaton to testify, given practically everything he might be able to say would be hearsay unless it's strictly about their interaction in Hawaii. However, I think the judge has already addressed that nothing that happened after this incident, once they moved to Idaho, I don't think any of that is going to be allowed to be put in. So I think he's already said that. So Hawaii stuff always happened after that. Justine, this is my theory too. She says 2 theories why she's calling Nate to keep him out of the courtroom or to testify about his interview with Summer at CrimeCon. Interesting. I mean, she could just ask Summer about her interview at CrimeCon. So let me just grab and get to the rest of the list. Okay. So after we have the bishop, we have the best friend, we have the bishop, we have the landlord, we have another best friend. Then Barry Cox, Lori's dad. Zachary Cox, who is Adam's son, who was living with the Coxes at the time this incident occurred. Adam Cox, who was the last person to text with Charles. Janice Cox, who is Lori's mother. Summer Shiflett, misspelled. Her last name is Shiflett with an F, but that's her sister. And then Brandon Boudreau, who is her ex-nephew, who the next case is about. So that is Lori's full witness list. And then she puts on there any item disclosed by the state, and the insufficiency of state's evidence is what she's going to argue. So it could be, yes, that she is just vindictive and she wants to confront Nate. Yeah, so it's not old events, it's events pertaining to the other case that they've already been convicted on. Exactly. Call Summer directly to the stand. No need to question her. I'm sure that Summer's probably also on the state's witness list, so Lori's going to have a chance to cross-examine her and then call her again if she wants to. So I just wanted to go ahead and go over her witness list so that you could see it. In case you missed it, I just wanted to get out of there, at which point I immediately told my husband, like, that was ridiculous. Like, nothing she said is valid. I don't know what that's in reference to, but it was a comment on the bottom of that document. So anyway, okay. So did I meet all of my agenda items? We talked about the motion Lori filed yesterday to block the officer from being an expert witness because she wasn't given enough time, but she herself did the same thing the next day with her expert witness. Oh, and I did want to tell you, her expert witness, his name is Lonnie Dworkin. When you look up his LinkedIn profile, he's got lots of initials after his name. I don't know what all of these mean, but ACE-CCE-NSA-IAM PMP, basically a computer forensics manager. And on his LinkedIn profile, there are several testimonials from colleagues that say that he's excellent at what he does. One person says his work is exceptional. His experience and understanding of computing, as well as legal intricacies, makes him an invaluable asset to your case, be it corporate or legal related. So he's a highly recommended expert. And I just want to note that Lori didn't disclose that she wanted him as an expert until this last Tuesday, which technically she's late on. So if she gets her report in on time and the state has time to review it and rebut it, we'll find all of that out on Tuesday's hearing, which is going to happen at 8:15 Arizona time. We went over the decisions that Judge Boreski noted. We went over Lori's witness list. And I just want to talk really quickly about my decision to attend trial. I am really interested to hear what Barry and Janice have to say. Yes, it is interesting to note as well, Kresha, that it's interesting that Barry, Adam, and Zach were all rated as zombies, or Z's to be technical, and Brandon Boudreaux all on Lori's list. Very wild. Interesting, right? Nate was in the future when this crime was committed. Yeah, I know what you're saying. Yes, Barry is Lori's dad. Janice is Lori's mom. And I'm getting ready to do kind of a deep dive on Barry, because I think that we hear a lot of Barry's voice in these legal arguments that Lori is making. Barry Cox wrote a book back in he published this book back in 2018-19 timeframe about how the American public can dismantle the IRS. He is a typical sovereign citizen type person, although I don't know if he's ever declared sovereign citizenship, but he certainly talks like one, acts like one. He sued the federal government, stating that the IRS is an illegal organization and none of us should have to pay taxes. And then he subsequently served time in jail for not paying his taxes. So that's where some of this comes from, and I'm going to do an episode on him this coming week. Just infuriating that Kay has to be questioned by Lori. Yes, but last I heard she was looking forward to that, but I know this is just, it's got to be a lot for her to deal with, and I don't envy her that. So yeah. I wonder if he's been guiding her too. So that's what I'm going to address. Okay, so I met with my team this morning, meaning my two kids who still live at home with me. And we talked about the possibility of me going to the trial. There are arguments both ways. Obviously, I don't like to be away from my kids. They kind of like it when I'm not here for reasons I've discussed before. I do kind of make it a good time for them when I'm not here. They help out with the dogs and the dishes and the cooking and all of that kind of stuff. And they get paid for that. So they like it. They like it when I'm not here. That being said, also, it's a long time for me to be gone. I definitely would want to be coming home on weekends. And so my preliminary idea is that I think I can make it for the first 3 weeks of the trial. I think it'll be important to be there for jury selection, especially since there won't be cameras in the courtroom. And so I think it'll be important to be able to recap a little bit as that is going along. I'm a little bit confused about the timeline, because I thought originally that the prosecution said that they would need 3 weeks for jury selection. But then when we were talking about it on Tuesday, or during the conference on Tuesday, jury selection starts on the 31st with the questionnaires that they're going to go over. And then in-person voir dire starts the very next day, which is a Tuesday, April 1st. And then Judge was saying he was expecting opening statements on the 7th of April, which is a week for jury selection. I also found it interesting that they are only going to send out 200 jury questionnaires. Now, Lori said that they went through 1,900 potential jurors in the Idaho case. I have not been able to corroborate that number, but that would be a huge amount to be able to question that many people. And I don't think the timeline lines up. So I actually texted Tom Evans and I was like, do you think 1,900 is the right number? And he said it sounds like a safe estimate, but I was like, well, it came from Lori. So I just wanted to double check. I don't know if she has her facts straight. So anyway, they're only going to send out 200 questionnaires. They only need 12 for the panel and then a few alternates. So arguably it's less than 10%, right, of the people that have to be qualified. So it'll be interesting to see what happens. Yeah, she was being serious when she said that they went through 1,900 people in the Idaho case. I don't know if that's accurate. It seems like a really high number to me. Again, I don't think that that number doesn't really jive with the timing and the number of people that they questioned in person and all of that. So I think this is right, Justine. They're going to send out the questionnaires, and of the questionnaires that they send out, they'll bring in 200 people. I think that's correct. Dr. Vonda K, good to see you. Yeah, I think Barry would have been very insulting about Chad. It'd be interesting to know his opinion, but I don't really care to ask him anything. So anyway, I'm a little confused about the timing, but what it looks like is jury selection would be the first week, opening statements and the state's case the following week, and the week after that. Then the fourth week of April, they've already stated, the state and the court have both stated that they're unavailable for that entire week. So court would be in recess for that fourth week of April. I'm just going to pull up my calendar just so I don't say something dumb and wrong. Oops, sorry. You can tell what I've been listening to. So we're talking the first week of April, jury selection, second week, opening statement, state's case, third week, probably state's case continued. Then that fourth week, the court will be in recess. The final week of April, the last few days of April, the first couple of days in May are when all of my crazy happy personal stuff is going on. So I will not be in court that week, but I will be listening and recapping as I can. I should be available, no problem, on Monday. Part of Tuesday, my recap Tuesday will be late. I'll be available Wednesday. And then Thursday, I fly out to be with my brand new grandbaby, hopefully. So I will recap probably either later that day or early in the morning on Friday before court starts, and then recap Friday. The following week, I'll be in California that whole week. So I probably will be doing that remotely, and I'll try to set it up so that I can live stream and then come in and comment during that week. And after that, we'll just have to see. They all seem to think that they would be finished with this trial by then, but that only gives the state 2 weeks and then Lori 1 week. So, maybe 2 weeks. So we'll see if they're wrapped up by then. I'm just going to have to play it with ear, but play it by ear. But so far, it seems like it makes sense for me to go the first 3 weeks and to come home during the weekends. So that may be what I do. I haven't decided yet. I think it's important for me to be there in person for a couple of different reasons, and I can't really explain exactly why. I feel it's important for me to see my Cox relatives face to face, to look them in the eye, and to just have them aware of my presence. I can't really explain exactly why I think that's important, but I do. And I think it's important to be there for jury selection since there won't be any cameras. Beyond that, it is important for me to meet some of the people who are in the area, who are, covering the case. And of course, I want to see Kay and Larry when he's going to be there. I hope Crush is going to be there for some of it at least. And so I want to see some of these people that have been supporting the channel and just network with some people and have a little, meet and greet type of a thing. After that, we will just have to see. Okay, this is interesting. Jojo says, nobody I know has any interest in this case in Mesa, Arizona. Every person I've asked say they've never heard of her. Weather is beautiful. Most don't watch news or TV. Interesting. That's good to know. Yeah, and I'm super excited for my good family time that's going to happen in the midst of all of this insanity. So yeah, I'm grateful for this too, Chelsea, that Charles sought help from police. It's so hard for me to watch those videos. Yeah, this is interesting. There's nothing Lori's family can say that's going to help her. It's all going to be smoke and mirrors. In my opinion, all of her witnesses are the state's witnesses. Wait and see. That's my gut feeling. Yep. So I agree with that too. I hope the judge is correct and they can seat a panel quickly as well. Maricopa County is a huge county, and this happened back in 2019, and this was prior to the children going missing or anything. So there may be a lot of people in the Phoenix area who don't even know about this case because the other case was so much more prominent. And the standard is they can know who Lori is, they can know about the case, but they cannot have formed an opinion about it. So even if they saw the Dateline interview or whatever, that was mostly about the kids and that part of the case. So anyway, her comments were. So anyway. Oh, interesting, Krusha. Makes me curious to whether the rumor was true that Barry gave Chad a blessing when Chad and Lori first met in St. George in 2018. Yeah. I honestly wouldn't be surprised. I mean, Barry liked to take advantage of any opportunity to give someone a blessing, to exercise his priesthood. So anyway, it'll be interesting to see. So what I have coming up tomorrow, I have a lovely interview with Lila Tuller, a former member of the LDS Church who is writing a book about spiritual abuse, and she is soliciting your stories about situations in which you might have experienced spiritual abuse. It's a lovely interview. She's a lovely, lovely person. I'm going to be posting that tomorrow to my YouTube channel. And then tonight, actually, I'm going on Web Sleuths to discuss basically everything that I've talked about here. I love Web Sleuths. They do such great work, and they support Authram, which is an organization that helps people identify the remains of their lost loved ones. I'm going to start this because I'm going to come back to it. Thank you. So that's happening tonight. Then tomorrow, the Lila Tuller interview. On Sunday, I have something on Sunday. I have to look at my calendar to even remember. It's not on my calendar. Maybe I don't have something on Sunday. I think Cultural Hall and I have an episode coming up. I usually do Tuesdays with Tim on Tuesday evenings. We'll see if I'm up for that. But Tuesday morning, for sure, I will be here once again for Lori's final pretrial conference, so that we're going to get all of the decisions on that. Yay, that's exciting. I'm glad. I can't wait to see you, Krusha. Thank you, Dr. Vonda K, for the super sticker. I appreciate you so much. Are the witnesses on the list being sequestered? Generally speaking, if you are not a designated victim or law enforcement, you cannot be present in the courtroom for any other testimony. So if that's what you mean by sequestered, then that's the general rule. Yeah, I should just relax on Sunday, right? Like, that's a normal thing to do. Thank you so much for this, sis. I did get your email. I don't think I've fully responded to it, or maybe I did and it was a long time ago, but I actually have it pulled up to go back over the people who offered help for Arizona. And I know you're one of those, as well as Joe Schmo. So I really appreciate that. And I will be reaching out for sure. Yeah, we'll see what we can figure out. Well, I mean, last time I got a hotel, and this time I may be staying with family or friends. So we'll just have to see. We'll have to see how it goes. So anyway, hope to see you tonight on Web Sleuths. Hope to see you back on the channel tomorrow for my interview with Lila Tuller. And then I will be back on Tuesday morning live again for Lori's status conference. We'll do the same thing as before. I will go through everything as it's being reported live from either Justin Lum or Nate Eaton or both. And then once the actual video is posted, I will live stream that as well, and we will talk about it and have comments, etc. So, oh my gosh, Kresha, we're gonna watch Step Brothers together, okay? We'll have so much room for activities. I can't believe it. Thanks, Elizabeth Jones. Good to know so many people are supporting from the UK and other places, Scotland, New Zealand, Australia. I really appreciate this worldwide audience. Thank you for being beautiful humans. Thank you for all your kindness and support. There was one comment from Kresha I wanted to address. I found that Charles called while in Texas about what to do with Lori and her odd behavior. This is who tipped him off to obtain mental health hold from CB. So there's a telephonic conversation we'll hear. Okay, good to know, Kresha. Thank you. Thank you for putting that on there. Okay, beautiful humans, go have a beautiful Friday evening. Hope to see you on Web Sleuths later. Please take care of yourself. Hey, there's 420 people in the chat. Please take a second to like on your way out. And if you're not subscribed, please subscribe to the channel. It's the best way to support. And if you become a channel member, I can promise you some bonus content. The higher the level, the more content you'll get. And good to see you guys. Take care, everybody, and have a wonderful